All right, let's talk about something that can be pretty stressful: credit defaults. We're going to break down the super strict rules a creditor has to follow before they can slap one on your file. And all our info today comes straight from the experts over at MyCRA Lawyers.
So, let's just get right to the heart of it, shall we? Can a creditor, if you owe them money, just decide one day to list a default against you whenever they feel like it? You know, there's this big urban myth out there in the world of Australian credit reporting. A lot of people just assume that, yeah, if I owe money, the creditor holds all the cards and can do what they want. But according to MyCRA Lawyers, that assumption is completely wrong. Yeah, I'm here to tell you that's just not how it works. Not even close. There are actually very strict legally required timeframes and steps that creditors must follow to the letter. And if they don't, well, that default might not be valid at all. So, what's the reality then? What does the law actually require them to do? Well, before a creditor can even think about listing a default, they have a legal duty to send you two very specific and, importantly, very separate notices. And these two notices are totally different. The first one, which is called a Section 6Q notice, is really just a formal heads up saying, hey, a payment is overdue. But that second one, the Section 21D3 notice, that's the really serious one. That's the official warning that a default is about to hit your credit file if you don't take action. Now, here's where it gets really crucial. It's not just about sending out the letters, it's all about the timing. This is a mandatory timeline where every single day literally counts. After sending that first notice, the Section 6Q, the creditor is legally required to stop and wait. They must wait a minimum of 30 days. They can't do anything else. Not 29 days, 30. Okay, so once that 30-day period is over and they've sent out the second, more serious notice, guess what? They have to wait again. This time, it's a minimum of another 14 days before they are legally allowed to actually list the default. And here's the final piece of the puzzle, the part so many creditors seem to get wrong. They only have a 3-month window from the date of that second notice to go ahead and list the default. If they're too late, if they miss that window, they've failed. So let's just walk through that one more time. Step 1, the Section 6U notice gets sent. Step 2, they wait at least 30 days. Step 3, the Section 21D3 notice gets sent. Step 4, they wait at least another 14 days. And only then can the default be listed, and it has to happen within that 3-month window. It's a very precise, non-negotiable process. Now you might be sitting there thinking, okay, that sounds pretty straightforward. But honestly, creditors get this wrong all the time, a lot of the time, because they're relying on automated computer systems that just aren't set up properly. And these are the classic mistakes we see over and over. They send both notices in the same envelope? That's invalid. They don't wait the full 30 days? Invalid. They jump the gun and list the default before that 14-day wait is up? Invalid. They list it after the 3-month window has closed? You guessed it, invalid. Heck, even sending it to your old address or simply not being able to prove they sent the notices at all can make the whole thing void. So what does this all lead to? It leads to a very important concept called an invalid default. And it's pretty much what it sounds like. It's a black mark on your credit history that, because the creditor failed to follow the rules, should not legally be there in the first place. And I really want to stress this point. These aren't just little loopholes or minor technical details. These are your legal rights written into law to make sure you get a fair chance to sort things out before your credit file gets damaged for the next 5 years. Okay, so let's tie this all together. What does this actually mean for you right now? Well, it's pretty simple. In this situation, knowledge really is power. It means that if you have a default on your credit file, you now have a very real, very solid reason to start questioning it, especially if you have no memory of receiving those two very specific notices in that very specific order. The burden of proof is on them, not you. So, I'll leave you with this final, powerful question to think about. Knowing what you know now about the strict legal timeline and all the common ways creditors mess it up, is that default sitting on your credit file actually valid? All the information we've gone through today was sourced directly from the team at MyCRA Lawyers, who are absolute specialists in this field. Thanks so much for tuning in.